friends, welcome to Tarunayas. Today we will be taking editorial analysis from the Hindu of 1st of November 2022. So our editorial is about the ambiguities of the reservation. Reservation has always been a hot topic, hot debatable topic, and there are always two sides of the coin. So reservation also has two sides. There is one side which is in favor of the reservation, the other side which is not in favor of the reservation. However, reservation since independence has been quite a topic, and there are always demand for the reservation arising from the different sections of the society. And recently in news what has been is the EWS quota. So instead of just discussing the EWS quota, we will try to discuss what reservation is about, what is the EWS quota, and how it can be challenged in the Supreme Court. Because if you remember that in the September, the constitutional bench headed by the Justice UU Lalit has reserved his judgment, reserved his judgment with respect to the petitions challenging the EWS quota. So we would see that what is the Indra judgment, and we would also see how the reservation India has been provided since independence. Even in fact before the independence also there was a reservation for the depressed classes as per the Government of India Act of 1935. So let us see all the facets of reservation. You can relate this article with your General Studies Paper 1 Indian Society, because if we look at the way the reservation has been provided, then the reservation first was provided to the depressed classes. That means ex-untouchables, those sections of the community who had faced the atrocities of the caste system and its dishumane or inhumane aspects of the untouchability. So in order to correct the wrongs, historical wrongs committed against a particular section or the large communities, section of the society, the reservation was provided in order, the positive discrimination mechanism was provided so as to alleviate their fears in the independent India, and as well as give them the equal opportunity, equal start. So first thing that we have to understand, that what basically is reservation. The reservation, the idea or the principle or the criteria of the reservation is not dependent upon the equality. So rather it is not dependent upon the equality, rather it is dependent upon the equity. So what is the difference between the two things, right? So you can also relate this with your General Studies Paper 2, that is Government Policies, Design and Issues Arising Out of Its Implementation, Mechanism, Law and Institutions for the Protection and for the Development of the Vulnerable Section of the Society. I have taken this article from the Hindu. In fact, this is not one article. These are the two articles which dealt with the EWS quota reservation and how it can be challenged in the Constitution. So the first article talks about that what could be the sequence of implementation of the EWS quota, what is the horizontal reservation and what is the vertical reservation. And the second article talks about what reservation per se is and what are the different facets of this EWS quota and how it can be challenged in the Constitution, and what would be the outcome of its implementation or its non-implementation. So we would see. So this is the article which I have taken. This is the editorial from the Hindu, and about the sequence of implementation. This is very important and a very interesting point that the writer has raised about the sequence of implementation. We will discuss what the vertical reservation and horizontal reservation is, and then we will understand what the sequence of implementation of the EWS quota is about, and according to the writer, how it can lead to different outcomes. So writer has given very interesting points, so we will see those points. The second article is from the text and context of the Hindu. It has basically sort of explained the different dimensions of the EWS reservation. But before the EWS reservation, we will first see what reservation basically is. See, reservation is a positive discrimination mechanism which should, according to the provisions provided in the Constitution of India, that means the mechanism to provide the positive discrimination is given in the Constitution itself. Now this results from one important aspect of the right to equality. So we will discuss what the two different aspects of right to equality is. In order to ensure the equality of representation, so this representation also we will discuss, because there are two facets of the representation. One is the proportional representation, and the other one is the adequate representation. So we will see what these two things means. In the public institution, we know the reservation is not applicable in the private institutions, except for the reservation for the education to the person with disabilities and the children according to the Right to Education Act. That is applicable for the private education institutions, but for the job and higher education institutions, only the public institutions are eligible for the reservation. Now let us look at the Article 14 and let's discuss the two different dimensions of Article 14. Let me clear this. Alright, so this is Article 14 of the Constitution. It has 2 points, 2 very important points. One is the right, this is this right to equality. So right to equality has 2 dimensions. One is the equality before law, and the other one is the equal protection of law. Equal protection of. Alright, so equality before law, that means everyone is equal before law. None of the person is to be discriminated if the two persons are situated in the similar conditions. Now this is another important provision in the Constitution, that if there are two people and they are situated in the similar condition, that means the right to equality is applicable if two people are socio-economic and politically equal. Then only the equality will prevail. If these two individuals are not equal, if they are unequal in terms of the social aspects, economic and the political aspect, how can the right to equality be applicable? Right? So the condition should be similar. So in the similar condition, equality before law is applicable, and the equal protection of law, that means every individual's rights and etc., they are equally protected by law. Equal protection of law, there the law protects them equally, right? So these are the two dimensions. These are the two dimensions of right to equality: the equality before law and the equal protection of law. All right. So we had discussed the definition of the reservation, and now we have also discussed that from where the reservation is coming. So the Article 14 is talking about the equality. Now if we look at the caste system of India, we will not go into the detail of the caste system that you can study in your Indian society, but if you look at the caste system of India, then it's a hierarchical organization with no vertical mobility. Downgrading from higher caste to lower caste is still possible. For example, outcasting. There were several mechanisms in the early history and ancient time that can be that resulted into basically loss of the higher status. So that is another aspect. But if we look at the hierarchical organization of the caste system, then there is no vertical higher mobility. A person who is born in a particular caste remains in that caste throughout the life till the birth, right? So therefore this caste system, it posed a challenge to the social democracy of India. So like Dr. Ambedkar said, that before we have a political democracy, we need to have a social democracy. So reservation to the ex-untouchables or the depressed classes, as defined in the Government of India Act of 1935, in fact the reservation to the depressed classes was given after the signing of the Pune Pact between the Dr. Ambedkar and Gandhiji. So this reservation was basically a kind of a push to the people who were marginalized due to this caste system. So this was a step towards the social democracy. So reservation was basically not a sort of a discrimination, rather it was a push to the people who were marginalized for more than 1,000 years, who had no representation in the political arena or the economic or the social. They had no social status. They were marginalized to the status of untouchable. So the purity and the pollution concept prevailed in India. So in such kind of condition, the new independent India could not have succeeded, could not have prospered. So we had to have an inclusive development. So everyone should be given equal opportunity and chance, but provided they all have an equal start. So if they all do not have an equal start, positive discrimination provides a mechanism to provide everybody a equal start. You cannot compare a person below the poverty line. So this is one interesting point that the writer has given, that how can you compare a person who is below the poverty line and the person who is subjected to the limits to the EWS quota, which is approximately to 8 lakh or 6 lakh, whatever the limit that the government is going to decide or has decided. We cannot compare the two individuals. They are not situated in the same socio-economic conditions. Therefore, the right to equality will not be applicable here. So therefore, there is a difference between the equality and equity. So far we have discussed the aspects of the reservation and from where the reservation comes. So this is the right to equality. The first, the Article 14. Let me clear this. The another article that provides for the positive discrimination mechanism of the reservation is the Article 16. Very important. Article 15 is also there. You might have watched the movie also. But so Article 15 provides for non-discrimination. Non-discrimination. Now, completely changing the social fabric of a country or a society is quite a Herculean task. It's a kind of it's a very big undertaking that a person shall take. Only a courageous person shall take such an undertaking to completely change the social fabric of a country, and in fact such a system which is so entrenched in the society. So non-discrimination is one aspect, and it's just not about the caste system, rather the gender, the creed, the religion, the place of birth, the place of residence. Not on the place of residence, because on the basis of the residence also, on the basis of the domicile also the reservation is given. So that one discrimination aspect can be taken. But the place of birth is the appropriate term given in this provision of the Article 15. That none of the people, that no citizen shall be discriminated on the basis of the religion, on the basis of the caste, on the basis of the religion, on the basis of the region, place of birth and gender. So on these aspects, and there is one term that is given, that is only on the basis of the caste, religion, region, creed, place of birth, right? So Indian Constitution, the language of the Indian Constitution is very important. Therefore, the role of the Supreme Court comes into picture when we say the interpretation of the Constitution, because the language has been written in such a manner that it does give the scope for the interpretation, the wider interpretation, as in case of the Article 21, and also limits the interpretation which was given in the basic structure doctrine, so as to keep the basic structure of the Constitution intact, so as to not deform it as per the whims and fancies of the ruling party, or the any person who comes into the power shall not be able to change the basic structure of the Constitution. That is so, and it does provide scope for the wider interpretation, and the Constitution does provide scope for the changes and for the amendments as per the changing socio-economic political fabric of the country. So we have discussed these are the three important articles that provide the reservation. Here, these are the basic articles. Yes, does SC and STs, they do have the representation in the Lok Sabha. Rajya Sabha does not provide for the reservation for the scheduled caste and scheduled tribe, but in Lok Sabha they do have. In state legislatures also they do have. So that is another aspect. We are not going into that aspect, but we are talking about the public institutions such as education and job, employment, etc. So 3 articles so far we've understood. Now let us move on. So constitutional provisions we have understood. Now there are 2 important judgments of the Supreme Court. One important judgment of the Supreme Court, and there is one important judgment by the Madras High Court. So we know that Article 17 provides for prohibition of untouchability. Right. However, this untouchability term is not defined anywhere, neither in the Constitution nor in the Act. But Madras High Court had actually in one of its judgment had provided that the untouchability implies the practice historically done, the practice to marginalize a section of the community, that what was the untouchability meant. So Madras High Court judgment is important here because it did define the untouchability, not exactly defined, but it did provide a scope that what actually it meant for the purpose of interpreting the constitution. Indra Sohani judgment becomes very important when it comes to the reservation, because the Supreme Court in the Indra Sohani judgment provided for two important points which are going to be discussed further, and on which basis the EWS quota is to be challenged. The first point is the 50% limit. So the Supreme Court said there is to be a 50% limit to the reservation, and within that 50% the reservation has to be provided to the various communities seeking reservation and who are eligible for the reservation as per the provisions of the constitution. And later on, the 103rd amendment amended the article 16 and provided for a fourth provision, that is economic condition. It provided for the economic condition. We will discuss that in the EWS quota, but first let us see what are the things that what are the judgments provided in the Indra Sohani case of the Supreme Court. 50% quota was provided, and the second important point that it said that the Narasimha Rao government had actually provided for a 10% reservation to the general category people who were not eligible into any of the reservation scheme on the basis of the economy. So economic criteria was there. So Supreme Court, what it did, it unconstitutionalized this provision and it provided for the 50% quota, and it did upheld the 27% quota given to the OBC, that is other backward classes, after the report of the Kaka Kalelkar and the Mandal Commission. So yes, 27% quota was provided, which was then implemented in the year 2006 onwards. Right. So we have discussed the constitutional provision. We did discuss the two important judgments, and Indra Sohani judgment is a very important judgment when it comes to determining the constitutionality of the reservation. For example, the Maratha reservation was quashed. It was held unconstitutional by the Supreme Court. Now let us look at the stages of the reservation, that how the reservation is provided in India and what has been the stages. What are the stages? The first reservation was provided. This is in fact not the first reservation. In fact, the Travancore, the ruler of the Travancore in 1880s, if I am not wrong, you can go and check it correctly, had provided reservation to the ex-untouchables in the public institution, provided for the entry into the temples, etc. So that is a very early case of the reservation. However, in the modern India, in the modern period, if we see that in the 1935, the depressed classes were given reservation under the joint electorate. So that is the political aspect. This is not job or education. Education was post-independent phenomena. To elevate the historical wrongs and to provide the level playing field to all sections of the society, especially the depressed classes. So SC/ST reservation comes from here, to correct the historical wrongs and to provide them the level playing field. Like I said, it is a reservation for scheduled caste and scheduled tribes was a push, and it was a push to the equality, push to the equal opportunity, in order to have a equal start, push towards the social democracy. And then comes the social educational backwardness, which provided reservation to the OBC, the 27% criteria. We did discuss the Kaka Kalelkar committee and the Mandal Commission. And the fourth time when the reservation was provided, it is the economic criteria, that is the EWS quota. Types of reservation. What are the types of reservation? There are two reservations. See, if we discuss the pros and cons of reservation, if we justify the reservation, if we see that if we see both the views, that what are the views which are against the reservation, what are the views which are in favor of the reservation, it's quite a debatable topic, and we will go on debating about it. However, what needs to be understood, that what was the motive or the purpose behind the reservation. don't we cannot only discuss one aspect that it is bad. Yes, the implementation could be bad. We do have to recognize lot the flaws in the implementation of the reservation, and how all sections of the communities are still not given due representation in the public and the education institutions. In fact, from the scheduled caste communities, the proper implementation is not there. That can be the issue. But if we are going to discuss that it is wrong altogether, then what about the developed countries which are providing reservation? For example, USA also provides reservation to the native people, to the Hispanics, and to they are also given reservation. So if we look at the history and if we look at across the globe, then the positive discrimination is a way to give certain section of the community an equal push, an equal start. An equal start I'm talking about. Somebody is starting from here. So for example, this is the finish line. A person is starting from here and the person is starting from here. In order to bridge this gap comes the positive reservation, the positive discrimination, that is reservation. So reservation cannot be altogether wrong, because we do have the socio-economic divide in our country. We do witness historically that how certain section of the communities were marginalized. So in order to give them the boost and the equal opportunity, reservation was there. Implementation can be the issue that can be discussed, needs to be improved. But saying that reservation is wrong altogether will be flawed ideology. So vertical reservation is there and horizontal reservation is there. In case of the vertical reservation, we have the reservation provided to SCs, STs and OBCs. And in case of the horizontal reservation, that means within these communities, in fact, for example, this is citizens of the India. So within the citizens of India, there will be some people belonging to various sections of the community, but they still would be subjected to the discrimination. For example, the person with disabilities and the women. So therefore, the horizontal reservation provides reservation to such kind of categories of people. And so yes, and also horizontal reservation is provided on the basis of the domicile. So such is the case. So we discussed that how the reservation has been implemented since the independence in India, and what are the types of reservation. Now let's look at what is the 103rd Constitutional Amendment Act. Basically, the 103rd Constitutional Amendment Act amended the Article 16 and provided for a clause 4th which talks about the education, which talks about the economy, not education. So 103rd, it amended the Article 16 of the Constitution, provided for a clause 4 which provides economy as the criteria for the reservation. Economically weaker section. So EWS. So 103rd Constitutional Amendment introduced special measures and reservation for the EWS category. So what are those special measures? So if you look at the Article 15, which amendment enables the state to take special measures in favor of the EWS, generally with an explicit subarticle and on admission to educational institutions with a maximum of 10% reservation. The Article 16 allows 10% reservation for EWS in public employment and does so in a manner that is different. Sorry for this. So different from reservations for scheduled caste, scheduled tribe and other backward classes. So this is the special measure which is provided for the EWS category and how the amendment has. Now let us talk about the overlapping VR categories and ambiguities. Now what happened now there is two important point that is needed to be understand. The reservation is basically a guaranteed minimum. It can exceed it shall not exceed the 50%. Shall not exceed the 50%. But that is the guaranteed minimum. So if there arises exceptional needs, so yes, it can be extended. Exceptional needs, a very exceptional needs. So it's a strong case for exceptional needs. Over and above criteria. Now what is this over and above criteria? It's very important. Now what happens? Suppose this is a person in the reserve category. Now this person shall be entitled to the open category position if this person falls in the merit of or the score in the open category position. and not be slotted under a VR position. So this person of a reserve category will go to the open category on the basis of the merit. So this is what is known as the over and above criteria, as it is called in the literature. The other one that we have is the guaranteed minimum. For example, for instance, if we have chalo, let's take the example of scheduled tribes. So if scheduled tribes, they have approximately 8% of the reservation or 12% of the reservation, now this is the guaranteed minimum कि इतना तो होगा ही, like this much has to be there. So that's why it is called as the guaranteed minimum. So let's see the stages of implementation. Like in one of the articles, the heading was written the sequence of implementation. Now what happens, the writer discussed, now this is particularly for the students of the sociology. You can quote this in your general, in your paper 2 paper, the caste and the reservation. We do study in sociology in Indian society, so this can be quoted in sociology, that in 2019 paper, the economist Rajesh Ramchandra and Deshpande, they had showed that under the current income limit of EWS reservation, more than 98% of the population qualifies, and if it is a political agenda, then the political leaders would try to include everyone. So the issue of this 10% reservation will not be applicable. Everyone is qualified for the reservation. Then who is eligible for the reservation? Everyone. 98% of the population qualifies. That means almost everyone is eligible. So what is the purpose of reservation then? So basically you are trying to compare a person with below poverty line. That means you are comparing the two people, a person below poverty line and the person having income less than 8 lakh rupees. So how can these two people can be compared? So this is what the writer is trying to say in their research paper. This can be case study for the sociology. So if sociology optional candidates are watching, then you can quote this in your paper. If EWS positions are allocated, after all other VR positions are filled, this will not arise. That means the sequence is very important. If you have the vertical reservation category first and then you are applying the EWS, then yes, the outcome will be different. This is what the writer is saying. But if you are applying the EWS category first and then the VR reservation, then everyone is eligible for the 10% reservation. So this is important. The writer also talked about the exclusion of the SCs, STs and etc. from this purview. So if economy is the criteria, then they should also be included here. So there are lot of points on which the EWS quota can be challenged. This is we are understanding. However, the writer says that economy criteria cannot be just one reason for unconstitutionalizing this quota. There could be many reasons, because yes, economic deprivation, the poverty and the economic deprivation, income deprivation does have a impact on the socio-economic development of a person. That is true. But the government has to decide that is reservation the only way to uplift a community? And why even after 75 years of our independence, we do seek reservation as the mechanism to uplift a certain section of the community? Why not we develop an institutional mechanism which is inherently equal, which does provide equal chance to everybody or equal opportunity to everybody? That should be the debate. Why do we have reservation even after 75 years of independence? We have different sections of the community rising and asking for reservation. Why there is not another mechanism for the economic prosperity of the people? Why do we still have socio-economic deprivation in our country? Why does the inequality report still provides that India is considered as the most unequal country? Why do we have 1% of the top rich people who does not even need reservation from the general category? They won't even apply for it because they go for higher studies abroad. They won't apply for the public institution, the 2%. And according to the inequality report, the top 1% holds 37% of the income. So we do have the income inequality. But is reservation the only criteria? Why not make public institutions accessible to everybody? Why not have education free for all, so that Why not enhances the productivity and the employability of the people? Why do we have unemployed youth asking for reservation? Why not we generating enough employment for the youth? Why are we not generating and establishing enough institutions for the mobilization of the youth in the productive sections or the dimensions of the economy? Why do we still have the youth standing either in favor of reservation or against reservation? That should not even be the debate. However, we cannot ignore and we cannot neglect the socio-economic realities of our country. So yes, the debate can go on. We can debate on this whole day, but that's it's not as a UPSC aspirant. That is not our purpose. Our purpose is to analyze issue objectively from the neutral perspective, that these are the points which are in favor and these are the points which are not in favor. So in this article also we are discussing it from the neutral perspective, that if that how the sequence matters. If we are giving the vertical reservation first and then the EWS quota, the outcome will be different. The below poverty line people would be beneficiaries of this reservation. But if you give the EWS quota first and then the VR reservation, then everybody is including, like according to this paper. So stages of the implementation, like I discussed, will have a different policy outcome. However, changing the income is like opening a Pandora box. So politicization of the reservation should not be there. We have to consider the outcomes of the reservation objectively, from the perspective that what the impact can be. So this is what the writer is trying to say. So the sequence is very important. So this is the writer is advising to the court that the implication of the implementation route should need to be observed carefully, so that there is no ambiguities, that is no loopholes are there. So constitutional examination of the EWS reservation will be on the basis of the Indra judgment, and so the writer is of the view in the Indra judgment of 1970s that economic criteria is an unconstitutional criteria. That is one point. The other one is that as the constitution was primarily concerned with addressing the social backwardness, not the economic backwardness. For economic prosperity is there. That is, you generate more employment, you generate more income, you enhance the productivity and the employability and the skill of the youth. So that is the way to the economic prosperity. That is, so therefore, this is what the writer is trying to say. These are not my personal opinions. So writer says that EWS status is transient. So if a person gains more income out of the reservation quota, this is what the writer is trying to say. But you have to fix the limit nicely. So writer is saying that income data should be there so that the limit is fixed appropriately, because the status is transient. It can be changed. Economic status in our country can be changed. There is an economic mobility. Social mobility, however, is impeded because of the hierarchical arrangement of our society. Social examination. So if you see that on September 27th, the constitutional bench, which was headed by Justice UU Lalit, the former Chief Justice of India UU Lalit, and heard the multiple petitions against this reservation, that how can the economic criteria be the sole criteria to introduce this, and etc etc. But after the extensive hearing, the bench has reserved its judgment in this case. So basic doctrine can be one thing. However, writer is of the view that economic criteria will not be like distorting the basic structure doctrine. We are not going to discuss the basic structure doctrine because the editorial will be too long then. So maybe in some other classes, some other editorial class, we will discuss the 1970s Keshwananda Bharti case and how it led to the evolvement of this basic structure doctrine and what this doctrine is, etc etc. So the writer says that if EWS reservation is to elevate poverty, then a person below poverty line and a person who is availing the EWS quota cannot be on the same platform. We discussed in Article 14 before we started the topic reservation, we did discuss in detail what this Article 14 meant and what are the two different dimensions on which the Article 14 is based upon. So poverty, the writer does recognize that poverty does inflict serious disadvantage, and it's the prerogative of the state to use the special measures, whether it is reservation is one of those means to address this poverty, right? So writer is of the view that reservation is one of the means, but it's not the only and the sole means. Like I discussed, you increase the employability and the skill of the youth, you generate more employment, you generate more jobs. so that the need of the economic criteria for reservation does not arise, because that is transient. So, challenge to the amendment may lie in the context of our Article 16, that the government had actually amended the Article 16 to provide for the economic criteria. So, adequate representation and proportional representation is important. If a section of the society is not proportionally represented, that is one point. However, the Supreme Court judgment is relied on the adequate representation, that it should be adequately represented, because we live in a democratic republic. So every society needs to be represented. So adequate representation is the criteria, not the proportional representation. So question and challenges, like I discussed, 50% rule, that cannot be, but because in extraordinary situation, higher proportions can be given. That is one thing. The definition could be a problem here, because if the politicization of the reservation is going to happen, the political leaders may change the definition, and an economic definition without the income data, proper empirical evidences and empirical data, income data, it's like opening a Pandora box. Like I said, you cannot compare the individual below poverty line and the person with the income less than 8 lakhs. So that's one, that's going to be um, it's going to be involve a constitutional jugglery at an unprecedented level. This is what the view of the writer is. So that's it for today. Thank you so much for watching Tarunayas. I hope you understood this topic well and without any biasness. I tried to explain this. So have a nice day then.